to all the participants for being here. And well, thank you very much to Alessandro Fabi who organized everything. I believe this is a very important moment. It's a reflection on a topic which is particularly intriguing. We were discussing with Professor Wagner earlier on the interesting underlying message of this idea by which private parties can agree on pretty much everything outside the civil procedure, the civil process, and yet there could be limits to their discretion, to their autonomy in regulating the procedure itself, because probably there are some public interests that kick in, but the discussion will be precisely on this. I would like to also thank the participants which cannot be with us but are connected online. I know that one of the speakers, Marco Gradi, will also be online. And I thank again all of you for animating the discussion and for what will be for sure a very interesting and intriguing seminar this afternoon. I hand over the floor to Professor Lupoi, who will chair the conversation this afternoon. And thanks again for your presence here in Catania, and very good afternoon to you all. Thank you very much.
Very good. It's a pleasure being here. I hope you can hear me. I hope that the guests online can hear me too. I feel privileged to have been invited to chair this international conference on a very interesting and current topic in comparative civil procedure today. It's a very busy afternoon, a lot of friends and colleagues who will make their presentations today, so I will skip an introduction and give the floor to our friend and colleague Marco Gradi, who is sick in Messina, and it is a pleasure to see him even in these circumstances. So the floor is yours, Marco, for the introductory remarks.
Thank you, Michele. I'm very glad to introduce this international conference dedicated to procedural agreements, organized by my friend and colleague, Professor Alessandro Fabi, at the prestigious University of Catania under the patronage of the European Law Institute and the Catania Lawyers Bar Association. At the same time, I'm very sorry not to be with you in personam, but unfortunately my health condition did not allow me to make the trip. I would like to start with a personal memory, which was the beginning of my friendship with Alessandro Fabi. We met in 2014 during an international seminar at the Max Planck Institute in Luxembourg, with the scholars as Remo Caponi, Rolf Sturner, and Peter Gottwald, in which we were presenting our research, and Alessandro presented a preliminary study on procedural agreements. This paper was then published in 2015 in the Max Planck series, but the topic has been the subject also of further studies of Professor Fabi. And I would like here to remember the essay on agreements in the US procedural system that was the result of research that he conducted at the New York University, available in English and then published in the Studies in Honor of Nicola Picardi in 2016. In subsequent years, he made some commentaries on the provisions of Italian Code of Civil Procedure that allows parties to regulate the arbitration process and allow the parties to derogate from the court's jurisdiction. And more recently, a new extensive essay on legal situation in civil litigation with a deep reconstruction of general theory forthcoming in the journal Il Processo. We can very well understand the interest of Alessandro Fabi in the topic, because the topic of procedural agreements is broad and fascinating and also challenging. The relationship between agreements and procedure can be considered from two perspectives. On the one hand, there are agreements directed to the settlement of the case and their reflection on the civil process. These are forms of consensual justice, or more traditionally, alternative dispute resolution methods such as mediation and negotiation. In this area, we have agreements that require a mediation or negotiation procedure to be carried out before going to court, but also conciliation agreements that have the effect of preventing the process from taking place. They are therefore contracts with procedural effects. On the other hand, there are agreements that affect the civil process. In this regard, we have agreements that could determine the choice of the judge. In particular, these can be the arbitration agreements that derogate from state justice to confer the case to arbitrators, but also agreements that allow, within certain limits, to choose the judge in domestic or international jurisdiction. We have also agreements that regulate the powers of the parties. For example, the right to make exception in the course of the proceeding, the right to ask enforcement measures, the right to appeal a judicial decision. And finally, we have agreements by which we try to affect the conduct of the process. Many questions open up with regard to the form and the nature of such agreements. We can also ask whether there is the possibility of involving not only the parties, but also the judge in the agreement, according to the principle of cooperation between parties and judges, which is exalted especially in simplified proceedings. This observation also brings us to reflect on agreements valid not only between parties in a single dispute, but considering also the agreements that have a collective value, i.e. protocols valid for a plurality of procedures. This is a trend that has spread in Italy in recent years, involving forms of soft law, the protocols that are concluded between the bar and the judiciary. But above all, the key issue is asking if procedural agreements are admitted not only when the law expressly allows them, but also when the law says nothing about them. This is the most complex and challenging aspect of the issue. There is a different approach for jurisdictional process and arbitration process. In the last case, it is permissible for the parties and arbitrators to regulate the conduct of the proceeding. With reference to the state process, on the contrary, the issue is more complex, because it is a question of introducing elements of privatization in a context of a process that is a public service. It is a process that is administered by a state body. So, in Italian doctrine, but also abroad, there is a widespread idea that think that this is not possible. The conventional process is forbidden. But there are also many voices against this traditional idea, not only in Italy, but also abroad, who question this procedural dogma. Here lies the great fascination of the topic. We have to face an important challenge. It requires to build a general theory of procedural acts and to take into consideration the complex question of will in the procedural acts. As Remo Caponi noted in a visionary paper in 2008, we are waiting in Italy a wide-ranging work that has the sensitivity, the courage, and even the patience to address the procedural agreements in a global perspective. With this goal, Alessandro Fabi has brought together today in Catania prominent scholars from all over the world who have dedicated important studies to the topic. At first, Michele Angelo Lupoi, who is chair in this conference, with his studies on the principle of cooperation between parties and judge in determining the rules of the trial. Gerhard Wagner, author of a very important monograph on procedural agreements published in German in 1998. Antonio Cabral, author of the monograph Convenções Processuais, published in Brazil and reaching its 4th edition in 2023, first edition 2016. Anna Nylund, who together with Antonio Cabral edited 2 collective works on the topic, Contractualization of Civil Litigation 2023 and Shaping Civil Litigation Using Procedural Agreements 2024. And also Elena D'Alessandro with their studies on third-party litigation funding, and Luca Penasa with his book in 2 volumes on jurisdiction agreements. And also finally Guillermo Schumann Barragan, author of the book Derecho, la tutela judicial efectiva y autonomía de la voluntad, los contratos procesuales, published in Spain in 2022 and winner of the Cappelletti Prize. In short, these are the top experts on the subject from a global perspective. Therefore, I'm certain that important insight will emerge from this conference. Thank you all and good work.
Thanks a lot, Marco, for your introductory remarks and for presenting the speakers today. Just a short announcement in Italian. Per gli avvocati che volessero registrare la presenza, mi chiedono di riferire che il foglietto è su quel, non so come definirlo, a destra, alla mia destra. Bene. Okay, let's switch back to English. We are almost following the time. So it's a pleasure for me to give the floor to Gerhard Wagner from the University of Berlin with a paper on procedural agreements and normative framework. Professor Wagner has a PowerPoint presentation which could be available There we go. Thanks a lot.
Thank you very much, Professor Lupoi, and thank you very much, Alessandro, for this invitation to this interesting conference that tackles a question that occurred to me some 25 years ago, and I discussed it with Dean Zappala before we started, namely, why is it that in substantive law, in private law, we have a principle of party autonomy, and the parties can pretty much do anything, not really, but within a certain framework. And in procedural law, it seems autonomy is kind of over, and then you are in a public law framework and everything is different. And at the same time, we all know that the parties are free to agree on arbitration, and then again, they can do pretty much anything. So the question is it really different when they go to court, and are they really constrained in the way that's commonly assumed that they are? I will tackle the issue in, well, 6 steps. I will briefly discuss what the concept of procedural agreement really means. Why is a contract of procedural nature not substantive? Then the main part is on freedom of contract in procedure. That's the issue I was talking about a minute ago. Then I am talking about the effects of procedural agreements insofar as they diverge from substantive contracts, commercial contracts. I briefly scanned the contract law of procedural agreements, meaning how are they brought about, offer and acceptance, stuff like that, the general law of contract, and then a brief look into international law. Are they subject to the lex furi or lex causes? These are important questions here. And finally, I take a brief look at empirical data or insights on the measure in which these contracts are actually used in practice. So this is the overview, and the first issue, as I indicated, is what is the concept of a procedural agreement, or what makes an agreement procedural and not substantive? That's the question, and it has puzzled, I think, many people, courts as well. In Germany, for instance, the courts oftentimes say that there are substantive agreements on procedural issues. I guess that's an oxymoron, that this doesn't exist, but agreements on procedural issues are in fact procedural contracts or procedural agreements. So the question whether a contract is of private law, public law, or procedural law nature is determined by the question of its subject matter. If the subject matter is procedural, then the agreement should be classified as procedural and not substantive. That brings us to the question, what makes a subject matter procedural in nature? Because if there is a dispute, every issue of the substantive law comes up in procedure as well. So it cannot, the concept cannot be that anything that comes up in procedure is of procedural nature. Otherwise, there would only be procedural agreements. So I think the concept is narrower, much narrower. The subject matter of a contract is procedural if it either changes the procedural rules that will apply to a future dispute, whatever it is, the dispute, I mean. The dispute is substantive, but if you change the rules of the game, then you're making a procedural agreement. For instance, if you change the venue of litigation, that you can't sue in the courts in Catania, but only in Rome, that would be an example of a procedural agreement. Or if you exclude resort to the public courts altogether in favor of arbitration, that's a procedural agreement, and some more. And a second category that is also procedural is if you engage in an obligation to exercise, or more importantly, not exercise procedural rights that you have as a party. A common example is if you waive the right to an appeal. You have the right to appeal, that's a procedural entitlement. If you make a contract on it, committing to not exercise it, that's a procedural agreement as well. Also, agreements not to nominate certain witnesses, not to call certain documents, and so on, in procedure, that would be the second category. So here, you're not changing the procedural rules, you're committing to exercise or not exercise a right that you have under these rules. So this is what I mean when I talk about procedural agreements, these two kinds of contracts. Now I confront this basic question, fundamental question, why is it that the principle of party autonomy doesn't apply to procedural agreements, or put otherwise, shouldn't it apply to procedural agreements just the same? And there are two common beliefs that I try to dismantle. One is that only because the procedure is not substantive in nature, and if you want to classify the legal system, belongs to the public sphere, it's public law, procedural law, that doesn't mean that party autonomy shouldn't play a role here. This would be a purely conceptual argument. It belongs in the public in the public sphere, therefore no party autonomy. That is not a good reason. And the second is that simply because it's an agreement, it must be substantive rather than procedural. This is the issue I tackled earlier. I think that the concept or the category of a contract or agreement is not tied to any subdivision of the legal system, for instance, to private law, but we have contracts all over. We have it in public international law, in private international law, in public law, administrative law, in European Union law. There are contracts everywhere. And so contract or agreement is a general legal category. It doesn't belong to any subdivision of the legal system. Now, the tendency or the inclination to deny any form of party autonomy in civil procedure comes from two concerns, I think. The one I discussed a minute ago, and the other one, that these agreements often take advantage of the weaker party. Before coming here, I took a look into the US literature on the subject, and it bristles with this concern that large corporations force agreements on consumers, something like class action waivers, in particular jury waivers, waivers of all kinds of procedural rights, and this is unfair. And because it's unfair, all these agreements are non-existent or shouldn't exist. There shouldn't be party autonomy. And I think that there is a problem with these kinds of agreements that are discussed in US literature, but it's not one about whether this type of agreement is legal legitimate at all. It's rather about a specific situation in which these agreements were made. For instance, by agreeing to a consumer agreeing to general terms of business of a corporation without the power to negotiate. And I tend to agree that there is a good reason for the legal system to intervene in this situation, but not with the heavy hand of declaring that all this is mandatory and all these agreements are illegal in nature, but only by addressing this particular contracting situation, like, for instance, EU law does with the unfair contract terms directive, or these instruments of court control over pre-formulated terms in B2C transactions. This, in my view, is the right place to deal with these problems, and not to declare that civil procedure is just a field of mandatory rules which allows for no agreements and derogation by the parties at all. I rather believe that the opposite principle should be the starting point of the analysis and the foundation of civil procedure, because the thing is that we all agree, I assume, that party autonomy is the governing principle of contract law, substantive contract law, and it has a corollary in civil procedure, and that's procedural autonomy. That's a fundamental principle of civil procedure as well, not often highlighted as such, but if you think about it, it becomes clear immediately. Nobody, for instance, is forced or obligated to file a claim to enforce one's rights. Nobody is under an obligation or forced to defend against claims that are brought against him or her. So that's all in the discretion of the parties. And why? Simply because these entitlements that are the subject matter of civil procedure are subject to autonomy as well. So there is a normative nexus between the substantive private law and civil procedure. And to see the difference, one can easily compare these institutions to the relevant ones in criminal law, where there is no discretion, at least not as a matter of legal principle, on the part of the prosecution to either prosecute or not prosecute, and there is no discretion on the part of the criminal to bring a sanction upon him or her simply by accepting it. That's not the way the criminal justice system works, and the reason is that the criminal law itself is different from private law. It is not based on party autonomy, and therefore the procedure was fitted to the subject matter, and the same here. And if you do the same here, you must accept that in principle there is party autonomy in procedure as well, and that these two principles of substantive and procedural economy coexist and must coexist, so that there is a presumption for party autonomy in procedural law as well. And by stating this thesis, I'm not saying that, let's say, more than 50% of procedural rules are subject to derogation by the parties. I'm just saying that you need a good reason to deny party autonomy in this area of the law as well. And I would be happy to admit that there are more good reasons to restrict autonomy in procedure than there are in substantive law. That's true. But unless there is a good reason to do so, one must not restrict the autonomy of the parties. So, particularly concern for the weaker party that characterizes the discussion or the restrictions or discussions of the restrictions on party autonomy, at least in Germany, but also in other legal systems. This is not a good reason, in the sense described earlier, to restrict party autonomy, because there are general contract law doctrines that take care of this problem, protection of the weaker party. And there are traditional forms of doing this. These are the rules on capacity, fraud, duress, and form. Statute of frauds provisions. These are well known. They date back to Roman times. We all know what they generally mean. And in modern times, they have been supplemented by a body of law that I've already touched upon, namely the control of unfair contract terms, pre-formulated terms, basically general terms of business. And ultimately, we also have another modern manifestation of this concern. We have competition law, abuse of a dominant position, and so on. So there is a lot going on in this area, and it all has to do with certain situations of contracting which, in essence, are not of a nature to ensure that the outcome reflects the true consent of both parties. Just as one example, there was, most of you will know, there was a rather spectacular decision of the European Court of Human Rights on a case of sports arbitration involving a speed skating competitor and athlete, and here the European Court of Human Rights was careful to emphasize that its concern was not with arbitration agreements in general, but its concern was with that particular situation that was before the court, namely that the athlete was forced effectively by economic concerns and by her interest to engage and to further her career and to participate in sports competitions at all. In order to be able to do this, she had to sign the arbitration agreement that was presented to her on a take it or leave it basis. That was the problem, not the arbitration agreement as such. And I think that is exactly the right approach. Whether there is a situation of unequal bargaining power and what the right outcome is, that may always be debated. That's not easy. But that's the way to discuss the problem, and not saying that certain procedural safeguards or rules are mandatory as such, right? It's about contracting situations and not about mandatory rules. But still, there remains a set of procedural rules which are not subject to derogation by the parties, where the public interest is in play. And that is always the case when there is a specific public interest involved, like if you're talking about publicity or access of the public to oral hearings. That was the subject matter in the ECHR case. Also, it's obvious that the access of the public to court hearings is not guaranteed in the interest of the parties, but in the interest of the justice system, or if you want, democracy and division of powers as a whole. The judiciary should be subject to control by the public. So that's not in the power of the parties to exclude, simply because it furthers or it looks at a public interest. That is, I think, the simple case of public interest limitations. The more difficult case is that there is in procedure, I guess, a general public interest that limits the ability of the parties to grab more of their fair share of scarce judicial resources than the one that's allocated to them by the respective procedural law. And to think about that, one has to imagine that everywhere, certainly in Italy, but also in Germany, there is, if you want, to put it into a metaphor, there is a queue before the courthouse. Parties are waiting in line for their case to be heard and resolved. And if the parties in that queue were free to inflate the proceedings or to have them not once but twice or three times until they like the result, then this queue would get longer and longer, and these agreements would actually be made to the detriment of other parties. They would externalize the additional cost to third parties who have to wait even longer for their case to be resolved. That suggests that procedural agreements that make the proceedings more complicated than they would otherwise be are not enforceable because they are against the public interest. And so, to my knowledge, almost everywhere it's impossible, for instance, to waive res judicata. The parties cannot jointly pull together and say, oh, this was so nice, we have a final judgment, but we want to do it all over again. It is permissible, interestingly, in arbitration. You can waive the res judicata effect of an arbitral award and have another arbitration. And why not? The parties are paying for it themselves. They're not taking away resources from others. But in the public court system, that's not permissible. Okay, so this was actually the last slide on this. I quote here from the Unfair Contract Terms Directive, which in its annex addresses explicitly certain procedural agreements like arbitration, which is not, or arbitral proceedings that are not the ones foreseen in the relevant Arbitration Act or the relevant provisions of national arbitration law. They also talk about burden of proof that's classified as a substantive issue in continental legal systems. But this is an example that the lawmakers have acknowledged that, first of all, procedural agreements such as arbitral agreements raise the concerns associated with the protection of the weaker party, and that they have also developed developed a tool to deal with that, and that is court control of unfair contract terms in certain situations, namely B2C transactions. And I think that's the right way to go. So in my view, to put it very shorthand, is to say we don't need mandatory rules so much. We can rely on court control over unfair contract terms to a much larger degree than before, let's say, in the 1950s or something when that was developed. This is what I said already, so I will not repeat myself. And now I will, in the remaining few minutes, just very briefly, because the normative thrust of my presentation is the one I've presented already, I will briefly touch upon a few subsequent questions. If you accept a broader domain for procedural agreements, then the first question that comes up, or one of the important questions, is what effects do they have? And there are two questions. Is it possible to enforce them specifically, to have an injunction or force parties to do what they promised? And secondly, is there a claim for damages in case of breach? Both questions are complicated. The first question can be rather easily disposed of in many situations, because these questions, or the effects of a procedural agreement, as the concept suggests, become manifest in proceedings. Then, if you have proceedings and a party doesn't behave as promised, you have a court that's already dealing with the case. So you don't have to initiate another set of proceedings to force parties to do what they're promised. So this is not an issue, the action or claim for a specific performance. It can be enforced, procedure agreements can be enforced within the procedure. For instance, a choice of court agreement can be enforced by the court whose jurisdiction was derogated from, that this court doesn't have jurisdiction and therefore doesn't accept the claim. And vice versa, the court which is vested with jurisdiction will entertain the action and in doing so enforce the agreement specifically. If a party waived its right to appeal, but nonetheless files an appeal, then the appeal is not permissible. It will be rejected. And therefore, in that way, the agreement will be enforced. Claims for damages are more questionable. With a view to arbitration agreements, they were accepted rather early. With a view to choice of court agreements, it is more complicated, more contested, the issue. I just want to briefly mention that in Germany, it was the dominant view that there is no damages claim in case of breach, but the German Supreme Court, in a judgment from 2020 or 21, I'm not sure, this is just the file number, finally accepted. It came around to accepting that if you breach a forum selection agreement, you're liable in damages. That was quite a step for this court to make. Now, the general law of contract, I just want to mention it very briefly, because this is a thing that has, I think, misled many courts and commentators, because legal systems, at least to my recollection, usually only have one general law of contract. They have not several, one for administrative law, one for public international law, another one here, another one there. There is one general law of contract, and that's usually codified in the civil codes that we all share in continental Europe, right? And so only because that is so, as just described, doesn't mean that all contracts are of private law, substantive law nature. That's what I said earlier. It also means that this body of general contract law, as codified in the respective civil code, also applies to procedural agreements by analogy or because it's just the general rule. And this applies to contract formation through offer and acceptance, rules of interpretation, conditions, succession, so assignment or succession at death, administrators of estates like receivers in bankruptcy and so on. They all succeed to these procedural agreements, and that's, as far as I can see, a common rule across legal systems. For instance, in arbitration, it's uniformly accepted that an assignee to the substantive claim also kind of inherits the arbitration agreement that is associated with that claim that was the subject matter of the assignment, and the same upon death, and so on. There are some problems with mistake and form. I have not the time to go into them. In international law, private international law, the question is whether these agreements are subject to the lex furi principle, or which means that the parties have no autonomy to choose the applicable law, or whether they can do so because they are subject to the lex causae. I suggest that the question whether the agreement is in fact operative, in the sense that the court that hears a claim or an appeal or whatever is bound, and this has the effects that the parties wanted, that's a question of the lex furi, whereas the question whether it was formed in a valid manner, that's for the lex causae. But as most of you will know, in arbitration, even the second point is heavily contested. Article 5.1a of the New York Convention of 1958, if you take that as a general rule, seems to imply that it is the court hearing the claim, or the petition for recognition and enforcement will decide whether the arbitration agreement is valid or not, applying the law of the seat. But it's a complicated thing. I just want to highlight this here. The last point I'm trying to make is practical relevance. Interestingly, in the US, as I said earlier, they focus on this protection of the weaker party policy, but also are very focused on the question whether these agreements actually play a role in practice and how important they are in practice. And of course, it's difficult to say, because there is no systematic collection of contracts which we could survey and scan for procedural agreements. There is one database where large corporations whose shares are traded on public stock exchanges, they need to file certain material contracts, material meaning important contracts, bet the company contracts, with the supervisory authority for the financial markets, the SEC. And this database has been analyzed for all kinds of purposes. And always the question is, how representative is it really for what's happening out there with contract law in general? There are millions of contracts, of course, and only a few are filed in this database. But if you take it as a valid source, then the outcome is that what's rather popular is that parties choose one system of procedure over another. And of course, the major agreements which do that are forum selection clauses, if you choose between jurisdictions, and arbitration clauses where you have your own system. But what they also find is that the more specific agreements, like agreements on the taking of evidence, document production, witnesses, experts, are less common. Then again, the exclusion of certain procedural entitlements, appeals, enforcement procedures, or setting aside procedures in arbitration are then more common. So it's difficult to say, but I think it's a straightforward, intuitive point that parties hesitate to sort of devise their own idiosyncratic procedural system. That would be quite a risky thing to do, but they either opt out of one system into another, or they make very specific changes to an existing system of procedure, like excluding appeals or certain witnesses, which don't raise the question of complexity, and which I would believe do not raise the question whether they compromise the general principle that the parties cannot force a more complicated, more complex procedure on the courts, because that would externalize the costs for third parties. Yes, so this is my conclusion. Procedural agreements are nothing to be afraid of. We have the tools to tackle questions of contractual fairness and equity, and we need not kind of petrify the procedural law only to ensure contractual fairness. Thank you.
Thanks a lot, Professor Wagner, for your excellent presentation, for setting the floor for a great discussion and for further for the following papers. You've given us food for thought about the new, the perspective for developments. We were discussing about with Marco Gradi about the need to have new visions about traditional ideas, and I think this is one of the topics where we think it's not even a matter of reconsidering, maybe it's just of building something new. Now, and thank you especially for being respectful of time, and so it's our friend Antonio Cabral, all the way from Brazil, to talk about the evidentiary agreements between party autonomy and judges' oversight. Antonio, the floor is yours.
Well, thank you, Professor Lupoy, dear friend. It is a pleasure for me to be here in Catania with all the colleagues and friends that are experts in this topic. Thank you, Professor Alessandro Fabi, Dean, and all the colleagues here in Sicily for this kind of invitation. Well, everyone that has researched, as we all have, procedural agreements have heard that this is a phantom, that this is a ghost that doesn't exist in civil procedure and procedural law in general. So I think Professor Fabi has gathered here what might be called the Ghostbusters. So we're all chasing them for quite some time. And it's a pleasure to see how far we went in this search. Well, the topic of my presentation is, let me see if I can share my screen. Did a brief incursion in practice. I'll try to bring to you how legal needs of the parties are framing evidentiary agreements in contracts that I found on the internet, and you can find them yourselves, and a brief survey on an empirical research that I'm conducting back home about agreements that are debated at the Brazilian judiciary. And I'll show you some of the numbers that are quite counterintuitive, one might say. Well, let me see if I can pass on.
Buongiorno, scusate a tutti se vi interrompo, non so se in aula mi sentite.
Well, as Gerhard Wagner said,
1, 2, 3, prova. Scusate, in aula mi state sentendo?
as Professor Wagner said, contracts and agreements used to be a tale of two separate worlds. We used to see procedural law as a matter of public interest, as a public service, and therefore no agreement of the parties could change, shape, or modify in any way the formalities of court proceedings. So traditional procedural law would reject them in general because of many arguments, mostly are here in my presentation. So procedural legal norms could only come from statutes, statutory law, but not from contract law. Fundamental guarantees of civil procedure would not be waivable. Parties could not dispose about them. The public nature of litigation would imply that every contract of the powers would interfere with judges' prerogatives, and this would not be valid. So therefore, a negotiated procedure would not be admissible in any case. Let me see. There. Well, anyway, as Gerhard Wagner said, this is all in the past. We can see a very strong worldwide trend of party autonomy in civil proceedings, especially, and also in criminal proceedings in some aspects. But let's focus on civil courts, in civil proceeding. This was a quest for economy. This was a search for efficiency and somewhat predictability. Parties want to know how their conflicts are going to evolve and how their conflicts are playing out in court. So this is an asset for the parties. This has value for everyone. We don't want to, once we file the lawsuit in court, we don't want to lose track of things, and we don't want to lose sight of the path that we're going to take until the final decision. So instead of going to arbitration, which was a possibility, parties began to try to shape in their own way court proceedings before state judges. And the basis, the normative basis for this usually stems from general provisions about freedom of contract, that Professor Wagner said, and the prerogatives of the parties to self-regulate them or self-regulate the dispute resolution proceedings that they want to be seen conducted to solve their disputes. So in general, when dealing with waivable rights, more and more, the general conclusion is that if parties can obtain a legal effect unilaterally in a given legal system, this same legal effect could be in subject matter of a contract, even if these effects are of procedural nature. So if parties want to obtain a procedural effect, and they could obtain it either by forfeiting rights or simply by not presenting an argument or not presenting an appeal, they could contract around this same effect. And in general, we are now beginning to see across various jurisdictions a conclusion that procedural contracts and agreements produce valid legal norms. So they derogate statutory provisions and courts are bound by them. So judges must apply the procedural norm even if it comes from a contract of the party. So the role of the courts is not one of simply ignoring contracts and deciding otherwise against parties' decisions or the party's will, but rather a role of supervision, control, and as Professor Wagner said, not of the convenience of adopting a certain legal norm or a certain proceeding, but a role of protection of weaker parties and protection of courts and the state's resources. So as Marco gently mentioned, I conducted with our colleague Anna Neeland, who is speaking in a few minutes to you, two international researches on this topic, and the findings of these projects are quite interesting. I won't be able to deal with them. It's just something to provoke our further discussions, but we can see that this movement, as I said, is worldwide, and we cannot see legal systems that are pro-agreements and legal systems that are against agreements if we put them in the general categories that we used to see in comparative law. So common law, civil law divide doesn't work. Europe, Latin America, Asia, or whatever doesn't work. We see, for example, countries like USA, Brazil, France, Belgium, the Netherlands. So South America, North America, Europe, common law, civil law. We see China and Taiwan, which somewhat could, especially China, could intuitively mean that they're against agreements and pro strong judges' control over the proceeding. So they're mostly pro-agreements. We see England, Wales, and Canada in a tendency of favoring parties' stipulations. On the other side, on the other end of this scale, we see some European countries like Poland, Hungary, Czech Republic, the former Soviet-influenced Eastern European countries on this side, and we see Italy and Spain, for example, as examples of legal systems that mostly reject procedural agreements. In the middle, somewhere in between these two extremes, we see different systems with tendency of favoring agreements. Germany, Japan, Argentina, Peru, Turkey, Portugal. So you see the portrait is quite interesting because it's a mosaic, and you cannot really divide countries in any way. That's what makes it perhaps really interesting in comparing. Anyway, I'll get into the point of evidentiary agreements about evidence. And here, I think if procedural agreements are a big debated topic in general, here the debate is even stronger. I would say of all the agreements that we can discuss, evidentiary agreements might be one topic of big disagreement in legal scholarship and legal practice. And usually in a given legal system, to see if evidentiary agreements are to be admissible or not, and how courts would react to them when they are examining a contract of the parties, well, their admissibility normally depends on two basic factors. First one is if in that legal system, evidence law is deemed to be part of substantive law or part of procedural law. And that's not an easy question because in many legal systems, including Italy and Brazil and many other countries in Europe and Latin America, there are some evidentiary rules that are not codified or disciplined or provided for in a code of civil procedure. They are in codes and statutes of private law. And that tells us something about this, because originally we thought about evidence as something instrumental to substantive law. And in many countries it is so until this day. So if you take it to the common law tradition, you see that many of the evidence law scholarship are divided from that of procedural law. So in college, for example, there are in the US or in England, there are chairs of evidence law. And the professor that teaches evidence law, it's not always a proceduralist. And that also said something about evidence law. And in some systems, some evidentiary agreements are admitted because in those systems, people understand that evidence law is part of substantive law. So if substantive rights, legal rights, are waivable, so evidence about those substantive legal rights should also be waivable. And in other legal systems, and the Latin sphere usually follows this second approach, evidence law is deemed to be part of procedural law. And therefore, the role of courts is understood as something stronger. And not everything about evidence should be in the hands of the parties. The second factor that tells us something about admissibility and validity of evidentiary agreements is the view that the role of courts will play in a given legal system when determining facts, fact-finding activity, and unveiling the truth. So the idea that what the judge has to relate to the truth, to the facts that actually happen in the life of the litigants. And these two factors are probably the most dominant factors that would tell us if in a given legal system evidentiary agreements will be admitted or not, and to what extent they would be admitted. So if we take a more public nature of litigation approach, the one that used to be the tradition all over the place, judges are seen as the central characters in evidence. Judges are seen as protagonists in fact-finding. It is said that the judges have the duty to apply statutory law, and therefore they have the duty to investigate facts on their own motion, ex officio investigation of facts. And there's usually also an argument that says that we cannot admit a negotiated truth. And here in Italy, there was a big argument made by our late colleague Michele Tarufo about this impossibility of a negotiated truth. Well, if you take a more flexible, more keen to private law approach, evidence should be seen as instrumental to substantive law. So parties would have a larger leeway to determine the rules of evidence to their own discretion. It is also used in argument that the cost of evidence ultimately is a burden on the parties. So there is kind of a strategy aspect of contracting about evidence. Otherwise, if you leave it on the hands of the judge and the parties cannot determine anything, maybe the cost of the discussion will supersede the costs of the assets under debate. So it makes no sense to shift it all and put it all on the hands of the courts. So evidentiary stipulations would be valid in general, unless the law prohibits it. And that is the approach as we will see a little bit further on in some legal systems. Well, one could think that whenever in a given legal system, the rules of the game establish powers of courts to produce evidence ex officio, this would mean that judges are not bound by evidentiary agreements, and therefore they could simply decide otherwise. They would see the evidentiary agreement and simply could ignore them and determine evidence on their own motion. But that is not enough, because it's not only a matter of seeing if in Germany or Brazil or Italy the law establishes prerogatives for judges to produce evidence on their own motion. We should see also if those prerogatives are to be interpreted as autonomous or subsidiary in relation to parties' possibilities to contract about it. Because if the powers of judges to determine evidence on their own motion are subsidiary to parties' initiatives, regardless if they like it or not, they are to apply the contracts that the parties made, because parties' agreements produce valid legal norms, and courts must apply valid legal norms, either if these norms come from statutes or come from contracts. And I agree with Professor Wagner when he says that we should rely on court supervision rather than simply say that, well, we are in procedure and public nature should avoid any contractual determinations. And the best way to deal with this is to establish limitations and control of parties' determinations, not simply by ignoring them. It's not the way to do it. And of course, procedural agreements can be used for evil purposes, but any legal institution can be used for legal purposes. Contract in general can be entered into to the detriment of vulnerable parties, can be entered into with illegal shifting of externalities in detriment even of the judiciary itself. But it's not a matter, if contracts can be used for evil purposes, what should we do? Do we simply ban contracts or say that they shouldn't exist in general, or should we develop mechanisms to control and to oversee them? Some comparative examples of what can be done in matter of evidentiary agreements: waiver of forensic evidence. It's really common in the US. Shifts of burden of proof. This is an expressly provided for agreement in several jurisdictions: Italy, Brazil, Switzerland. It's valid in France, the Netherlands, Sweden, Belgium, and many other countries. Limitation of number of witnesses on each side, saying that everyone's going to be maximum of 3 witnesses, each party, for example. A big debated issue is that one of if the parties can contract about the evaluation of evidence, if they could establish standards of proof higher or lower depending on the subject matter of the dispute. These are deemed valid in Scandinavia. If I recall, they're not deemed valid in Germany. And there's a big debate on what could be done in this particular aspect. So agreements about standards of proof. And in this point, it usually depends on that view in a certain legal system that one has about the nature of evidentiary rules. If rules are deemed to be more related to substantive law, then agreements to the standards of proof are usually acceptable. If rules of evidence are more inclined to be included within procedural norms, then these systems tend to avoid agreements on standards of proof. There can be agreements about means of evidence. Turkey, for example, has a general provision that allows parties to deviate from statutory provisions and design the procedure for producing evidence otherwise. Brazil has several types of specifically provided for agreements. Parties can agree to retrieve from the docket a document whose authenticity is being questioned. They can contract to alter the order of testimonies. They can choose specific electronic means that will ensure that an electronic document is to be considered integrate and authentic, and many other types of provisions. There are also very common provisions of evidentiary agreements. There are the stipulations of facts. In the common law world, these exist even in criminal proceedings. Parties say that a certain fact is to be considered as having occurred or not occurred. For example, if in a labor dispute, parties can agree that the employee had for that whole period of time a 30-minute break every day to have lunch. And if parties agree to that fact, the judge cannot consider that fact otherwise differently from what was agreed by the parties. Parties can make agreements on presumptions. Parties can choose the legal expert, which in some countries is something very exotic, because judges are supposed to appoint experts as they wish. And in the Latin tradition, in many countries, we see that as a curiosity. We see that as a very bad habit. Sometimes judges appoint relatives and so on, and that is not to be not a good practice to be seen as an example. In many countries, there are specific provisions that allow parties to choose the expert, and that is binding on the judge. And interestingly enough, the European Rules of Civil Procedure, which is a document of soft law, but should represent the state of the art of European procedural law, has 2 rules, 119 and 120, that admit the choice, the joint expert appointment, and state that courts are bound by the parties' election. So now I give you some examples of, as I said, these are contracts that I took from the internet. It's quite easy to get templates of contracts in any language if you want. These were all taken on the internet. As I said, you can make this research yourselves. This is an agreement about the burden of proof. This other is an agreement that says how an electronic document is to be considered signed by the parties. Let me take this off. This is a waiver of testimonial evidence. This is an agreement that says that commercial books from a company are to be considered the only mean of evidence to provide proof of certain facts, excluding other possible evidence that could be produced in that sense, for example, testimonies and so on. This is an agreement about a presumption that says that any claim of indemnization should be determined by an independent counsel, and if that independent counsel decides, then the party should have the burden to overcome that presumption, that establishing a higher standard even for considering or concluding otherwise as the independent counsel. This is a joint expert determination that shows a program of my university as an expert in a certain case, and the sole paragraph, it distributes the cost of that forensic evidence. And I get to this empirical research that I'm conducting on 92 courts. Brazil has 92 courts all over every jurisdiction, including higher courts and specifically specialized courts, labor, etc. So 92 courts from 2016 to 2024. 2016 was when our new Code of Civil Procedure was enacted. And of course, as Professor Wagner said, it's really hard to obtain data that is reliable about agreements because they don't happen in the judiciary. They happen in day-to-day contractual life. So millions and millions of contracts are entered into every day in the whole world. And so agreements tend to be under the radar, so to speak. But we took as a sample the discussions of agreements in the judiciary. If they don't represent the whole world of agreements, they represent at least what's being debated about them at the judiciary. And some data, and that was especially interesting for my presentation today, are really counterintuitive because the findings that we have so far say that more than 50% of what's being debated in the Brazilian judiciary about procedural agreements relates to evidence, stipulation of facts, agreements to shift the burden of proof, cost of evidence, waivers of testimony, waivers of documents, establishment of electronic means to guarantee authenticity to documents, etc., to borrow evidence from one procedure to the other, and parties agree that the evidence can be borrowed and can be evaluated, so it doesn't have to be repeated in a certain. So there are a large amount of agreements about evidence. So what I wish to stress with this graphic is that there is an undeniable legal need for contracting about evidence. Parties want to have evidence in a short leash. And that tells us something about this topic. We have to debate seriously evidentiary agreements, not with the prior prejudices that we have seen for decades in procedural law, simply rejecting them, ignoring them, because they exist, they are a reality, and we need them somehow. And that's why I could only thank Alessandro and the University of Catania for allowing me to bring some of these insights to debate here. So as a conclusion, I would say that in many legal systems, evidence can be in some measure disposed about. We can't say that we're all on the same page because there are considerable variations between legal systems, but there is an undeniable trend to favor evidentiary agreements, and we see that in practice. Evidence should be waivable, in my opinion, whenever a legal right is to be considered waivable. So the assumption of that we have seen historically, that in every procedure there is public interest everywhere is not right. We should search for the spaces in which parties in some system are entitled to self-regulate. And we can see those spaces, even Italy or Spain or legal systems that have until today a stronger rejection to this topic. The role of courts should be that Professor Wagner told us earlier. Supervision, control, and the search for specific types of legal rights in which vulnerable litigants are in play, or in which the resources of judiciary are being illegally disposed by the parties. And the search for equilibrium is the key here. We don't want to abandon the idea that justice is a public service. We don't want to abandon the idea that the role of courts is an important thing, and of course an important guarantee of the citizens. But we cannot deny that our spaces larger and larger for private autonomy in procedural law. It simply is a legal need that we see all over the world, and we can't simply stop the wind with our hands. Even if we want to, we wouldn't be able to. So I thank you very much for your attention. I'll leave my contacts here for further discussion.
Thanks a lot to Professor Antonio Cabral for this insight into evidentiary agreements. When he was mentioning the traditional debate about substance and procedure as concerns evidence, I was thinking that maybe a game changer, at least in the relations between the states of the European Union, is the role of EU regulation on evidence. So they might, that regulation might have brought down the wall of Lex 40 and maybe bringing some change into for future developments. But I agree with you, Antonio. This is a field where changes are needed. Now it's the time to give the floor to Anna Nilund, who should be. Yes, I see her. She has been mentioned already several times today, so it's a pleasure to see her again. Connected. She's from the University of Bergen, and she will talk to us about procedural agreements and ADR. The virtual floor is yours, Anna.
Thank you so much. You can't hear me. Let's see.
Maybe you're muted.
Mm-mm.
Mm-hmm.
Mm-mm.
I don't.
Can you hear me now?
We have.
Can you hear me?
No.
No?
Do I have to do something here with the computer?
No, I think so. Okay, the technician is coming up.
Can you hear me? Can you hear me now?
It's our problem.
Because, yeah.
No, it appears to be working here.
Okay, can you hear me?
Hmm.
No? See, I'll try.
Hmm. I don't know. Yes, I think that she can hear us. You can hear her,
Yeah,
right?
I can hear you, yes. But can you hear me?
And apparently here the microphone is unmuted.
1 minute and
Yes. We are practically on time.
Can you hear me? I'll see if I try without.
We can't hear you.
Can you hear me now? Can you hear me now? Now I can't hear you. Okay.
Apparently they can hear her online. So why can't we hear her?
Can you hear me?
Vediamo un attimo. No. Io? Qui?
Can you hear me?
This?
No?
This here? This one?
Ah, sta
This one, we tried
arrivando.
already.
Help is coming.
Ok.
Abbiamo fatto qualcosa che non dovevamo fare. Can you talk, Anna?
Yes, I can try. Do you hear me now? Can you hear me? No? Hello, hello. Because I can hear you. I hear you.
Sì, magari possiamo chiedere a lei di uscire e ingressare.
Yes, Anna,
Can you hear me?
the advice that they give me is if you could exit
Exit the meeting.
call and then come back. And I have a little proposal in my role as chair while we solve your technical problem, Anna, in order to try to stay on schedule. Elena, would you like to? So my proposal, if Alessandro agrees, is to give the floor now to Elena and Alessandro, then have 5 minutes break, as we were mentioning before. We solve Anna's problem and we give the floor to Anna. Yes, if you agree, Anna.
Yes, yes.
Can we do that? Okay, thanks. Body language works. Okay. So now, a small change of plan, momentarily, anyway, a little change of plan. Elena D'Alessandro from the University of Turin will talk to us about third-party litigation funding, a new category of agreements sitting between private law contracts and procedural agreements. Elena?
So thank you, Michele. Good afternoon, everyone. I'm delighted to be here. Therefore, before starting my presentation, let me express my gratitude to the organizer, the University of Catania. Alessandro, thank you so much for inviting me and giving me the opportunity to share my 2 cents. I wouldn't say my talks. I would prefer to say like my 2 cents on a topic that is third-party funding agreements, which I considered connected with the main topic of this conference, that are procedural agreements. So I have my PowerPoint presentation. I try to share my presentation with you. I assume that my presentation, yeah, it's going on. Okay. So my presentation, my presentation is divided into 2 parts. I will firstly introduce you to private litigation funding instruments, just to set the scene. And then I will try to answer to the following research question. What kind of agreements are third-party funding agreements? So are they pure private law contracts? So shall we apply 100% the principle of party autonomy? Or even though they are not procedural agreements, shall we reach the conclusion that they share some features with procedural agreement? And is it enough to say that for this reason, because there is a public interest to protect, we have to limit the principle of party autonomy? And if it is so, that's the reason why I'm in my presentation, the title of my presentation, I use the word an in-between category. If we have to limit the principle of party autonomy, there are 2 questions that we have to answer. Number 1, in which way? So in which way we have to limit the party autonomy? And number two, with which legal instruments? So these are the two questions that I will try to answer during my presentation. Let me firstly set the scene just for the benefit of the students that I see as participants. So the starting point is the loser pays principle, which applies almost everywhere within the EU. So that is the cost of civil proceedings are to be borne by the losing party. So at the end of the proceedings, the winning party should be put in the same position, including financially, as if there had been no need to start the proceeding. But the point is that the loser pays principle in itself is not enough to guarantee the right to access to justice for those who cannot afford the cost of a civil action. This is because civil proceedings come with costs, for example, cost of evidence. And so it's just at the end of the proceedings that we apply the loser pays principle, and therefore it means that each party has to support the cost, to anticipate the cost of a civil litigation. So the question is, what instruments shall we offer to those who cannot afford the cost of a litigation, of civil litigation? What kind of instrument should we offer to the less powerful party? And finally, what legal instrument shall we offer for mitigating litigation risk? This is also an obstacle for someone to, in order to start a litigation. So it is true that each state has its public law litigation funding system, that is legal aid, but number one, legal aid is only for natural persons, and it is only for a small percentage of potential claimants. And if such legal requirements are not fulfilled, then there is a big space for the so-called private litigation funding instruments. And in fact, and this is the reason why the topic is relevant for the purposes of this conference, there is a growing market in Europe for private litigation funding instruments. And here you have a sort of visual help with a variety of private litigation funding instruments, which are all not for free. So they are not for free. And I will focus on third-party litigation funding. So now I will move to the second part of my presentation, just try to determine which kind of agreements are the so-called third-party funding agreements. And I will start with the definition of litigation funder and with the definition of a third-party funding agreement. So I will make reference to the VOS draft directive, that is the European Parliament draft directive drafted by the German Euro Parliamentary VOS. The draft directive is, for the moment, it has been put to the attention to the European Commission, and the European Commission has decided to start a study on litigation funding, and then at the end of the study, with the result of the study in their hands, to decide whether or not to enact a directive on third-party funding. And on the other side of the screen, you will find the ELI third-party litigation funding principle. So the ELI has established a working group to work on third-party funding, and so the working group has drafted the ELI third-party litigation funding principles, which has been approved by the ELI at the end of September, beginning of October, if I remember correctly. So here you have in the screen the definition of litigation funder by the VOS draft directive and by the ELI principle. Both the definition are coinciding in the fact that the third-party funder is acting on a commercial basis. Basically, the funder is speculating on the results of a civil proceedings, or which can be a proceeding in court, or as clarified by the ELI principle, which can also be an arbitration proceeding, a negotiation, or a mediation proceedings. And then I move to the definition of third-party funding agreement, once again taking as a reference the VOS draft directive and the ELI principles, into brackets. The ELI UNIDROIT principle on civil procedure, they endorse third-party funding, but if you look at the ELI UNIDROIT principles, you will not find a definition of third-party funding agreement. They just endorse the use of third-party funding without defining what a third-party funding agreement is. So basically, once again, the VOS draft directive and the ELI principle definition, they both coincide on the fact that the funded party and the funder agrees to have a litigation or an arbitration or an out-of-court proceedings funded by the funder, and the funder is not acting for free. A remuneration fee is due if and only if the funded party is successful. So we can agree on the fact that third-party funding agreement is a private law agreement. So in principle, we have to make reference to the party autonomy. But the fact is that even though third-party funding agreements are in principle private contracts, so a third-party funding agreement has not direct effect on a civil proceedings. The fact is that such kind of agreements may have an indirect impact on a civil proceedings, and that's the point. I will give you some examples. So here you have a scheme of a litigation funding agreement, assuming that the funded party is the claimant. It can also be the defendant, but in the majority of the case, the funded party is the claimant. In continental Europe, litigation funding agreements are agreements between a funder and a funded party, in this case, the claimant. And the claimant's lawyer is not a party of the litigation funding agreement. But the lawyer is paid by the funder, and in many litigation funding agreements, there is a clause according to which the funded party is under a duty to instruct his or her lawyers to keep updated the funder about the ongoing of the proceedings. So the question is, who has the case management control? Who is deciding the procedural strategy? And what happens if it is the funder and not the lawyers to determine 100% the procedural strategy? Once again, the question is, shall we leave this aspect 100% regulated by the party autonomy, or shall we say that because there is a public interest, and the public interest is the fact that we are talking about a procedural conduct, should we have to limit in a certain way the party autonomy in respect of these aspects? Another example, here you have the website of a funder that is Omnibridge, which is acting within the European judicial area. And as you can see, among the many services that Omnibridge is offering to their clients, there is also they are also offering a lawyer to you. If you are a potential claimant, if you want to bring an action, and if you are looking for a third-party funding, but you do not have your lawyer, ask us, and we can suggest you the name of one lawyer. And of course, this is a lawyer having a sort of relationship with the funder. Once again, is this enough to say that there is a public interest? It is enough to say that we must limit the party autonomy? And again, another example. So here we are talking about individual actions in court. I'm excluding representative actions, because for representative actions we have, according to the EU Directive 1828 of 2022, if I remember correctly, 2020, sorry, there is a rule regulated conflict of interest for representative actions. So the claimant is under a duty to disclose the existence of a third-party funding agreement. And again, for arbitration, many regulation of arbitral chambers, they have established a duty for the funded party to disclose to the arbitral tribunal the existence of a third-party funding agreement and the name of the funder. But when we are talking about individual actions in court, at the present time, at least in Europe, according to my knowledge, there is no procedural rules which impose to the funded party a duty to disclose to the court, number one, the existence of a third-party funding agreement, and number two, to disclose the name of the funder. And so what's the problem? What can be, in this case, the indirect impact on a civil proceedings? The fact is that the court, if there is no duty to disclose the existence of a third-party funding agreement and the name of the funder, the court cannot check whether the funder can be in a conflict of interest with one of the parties. I'm referring to revenge third-party funding. I'm also referring to the case, and there is Swiss case law in that respect, a case in which the defendant's lawyer, and the defendant was not the funded party in that case, had an economic interest in the funder. So in the Swiss case, the defendant's lawyer had invested money in the funder corporation. And therefore, in such a situation, there can be a potential conflict of interest for the lawyer who is under a duty to represent the defendant, but has an economic interest in having the claimant winning the case and the funder receiving the remuneration fee. And without any duty to disclose the existence to a third-party funding agreement to the court is not in a situation to ascertain this kind of conflict of interest. And finally, the last point which must be considered is that the funder's return rate. At the present time, the situation is that we apply the principle of freedom of contract, the party autonomy. So the only cap that we have is the public policy clause. And in that respect, there is German case law, not the BGA, but the Court of Appeal of Munich, if I remember correctly, saying that if the funder remuneration fee exceeds the 50%, then such a provision shall be considered in breach of the public policy. And therefore, the funder remuneration fee shall be reduced according to due to the application of the public policy clause. What is the point? Is that if we apply 100% the principle of the party autonomy, and if the funder's remuneration fee is too high, then the result, and this is the indirect impact on a civil proceeding, is that the funded party, that is the winning party, will practically lose the economic benefit that such a party reached winning the case. And so I will show you an example. I will give you an example which is borrowed by this English report. The example is borrowed by the Review of Litigation Funding, that is a document which has been published by the Civil Justice Council. And it is an example which is related to the British Post Office scandal. I'm sure you remember, you know about the British Post Office scandal. There was a scandal in the UK involving thousands of innocent sub-postmarkets which were convicted for apparent financial shortfalls, and many of them were forced to pay with their own money, with this for this shortfall, and at the end of the day, they realized that there were no shortfalls. And therefore, some of these postmasters, they brought a group litigation in the UK against the British Post Office. And so in the group litigation, they reached a settlement, and the value of the settlement was £57.75 million. The claim was funded through third-party funding, and therefore, as usual, every time that there is a settlement is reached between the funded party and the counterparty, the funding is pre-deducting its remuneration fee. And in this case, only £12 million were left to the claimant. So at the end of the day, the net effect was that each sub-postmaster received only £20,000 in damages instead of £99 of damages. This was the amount of the funder remuneration fee. So taking these examples into consideration, what is the main point, the key question on the table? Once again, even though third-party funding agreements are not procedural agreements in a pure sense, do we have to limit the freedom of contract of the parties because such kind of agreements may have, not always ever, but they may have an indirect impact on a civil proceedings. So, and just because the rules governing civil proceedings have a public law nature. I'm persuaded that some safeguards are needed, in particular about disclosure. We can discuss about how to put a cap on remuneration fees. We can decide to put a cap, or we can decide one of the proposals that was under discussion at the European Parliament was simply to impose to the funders a duty to disclose and to make public on the funders' website the amount of the funders' of the remuneration fees which were needed, which were requested, in order to let the market decide which funder is offering the best solution. And if we reach the conclusion that even though these are not procedural agreements, notwithstanding that, we have to limit the party autonomy. The second question is, in which way? What is the instrument that can be used? So once again, there are three possibilities: our law, statutes, for example, an EU directive. Outside Europe, Singapore, Hong Kong, they have enacted law to regulate some aspects of third-party funding agreement, or the alternative is soft law. I'm referring to the Code of Conduct, which are, for example, in use in this moment in the UK. But let me quote the Jackson Cost Review, which was drafted in 2009. At that time, the Jackson Cost Review reached the conclusion that for that situation in 2009, for the way in which the third-party funding market was structured in the UK at that time, self-regulation was the best approach. But the conclusion was, if the market expanded, the question of full statutory regulation should be revisited. And that's the reason why in the UK now is under discussion whether or not to revisit and to think about a statute regulation of third-party funding, because they realize that the self-regulation is not 100% the best option, as many of the funders which are acting in the UK market are not bound by the UK Code of Conduct, because of course they did not agree so become party of the Code of Conduct of the Funder Association, and they did not accept the Code of Conduct. And the last strategy is the proposal made by the ELI third-party funding principles approach. So they are offering some guidance. The purpose of this principle is, number one, to help the parties to draft the third-party funding agreements. And so the idea is to make the parties, and in particular, make the funded party aware of what are the risks, what are the pros, but what are also the cons of entering into a third-party funding agreement. And so this is the first purpose of the ELI third-party funding litigation principles. And so in the introduction, the principle also add that hopefully some legislator can take inspiration by this principle. But let me add some thought in that respect. If we are thinking to introduce some safeguard in respect of third-party funding agreement, we must not only take into consideration the funded party, so the funded party shall be when drafting the third-party funding agreement, of course, shall be 100% aware of what are the cons and what are the risks related to a third-party funding agreement. But we must also take into consideration the counterparty, that is the opposing party, because the opposing party can also suffer some consequences by the fact that the other party is helped by a funder. For example, the evidentiary cost of the proceedings can increase, and there are other aspects that, in my opinion, might be taken into consideration. For example, the conflict of interest, the revenge funding, and so on and so forth. And so once again, my conclusion is that these are probably the new frontiers of this topic. It's not a procedural agreement, but there are some features, in my opinion, in common with procedural agreement. Some of the problems that we touch with procedural agreement are also common problems with respect of third-party funding agreement. And there is a lot of food for talks because really we have to decide at the European level, but I think also globally, because other states are thinking, are in this moment reflecting on whether or not to regulate third-party funding and in which way, how to strike a balance between the party autonomy and the need to protect the public interest of civil proceedings. And this what I just wanted to put on the table in order to stimulate the discussion. Thank you so much for your attention.
Thanks a lot, Elena. Yeah, one may agree that third-party funding agreements are not procedural agreements as has been defined by Professor Wagner earlier, but one could also say, well, they are the definitive procedural agreements in so much as they allow proceedings to be started in the first place, so you couldn't do the proceeding without them. Yeah, it's a perspective. I mean, I don't want to go into details here, but it's an industry which is growing. I have been contacted online by somebody on LinkedIn asking me whether I was interested as a professional in third-party funding. And as concerns the counterparty, I can imagine that for a defendant or for a claimant to be facing an opposing party who has external funding can put a lot of pressure, I mean, into, considering the options of keeping on the litigation, especially in very expensive systems like the UK or others. Would you like to add something? No? Because I saw you turned on.
I just wanted to, the final remark. It's a growing market. in Italy too, notwithstanding the fact that we are well known for the excessive length of our proceedings, and of course, one of the main interests of the funder is to having the return their money back as soon as possible. But notwithstanding that, for example, in insolvency proceedings, there is a growing market in Italy for third-party funding.
Well, I get we have a lot of litigation, so I guess it makes sense in a way. Okay, so thanks a lot again, Elena. Now, as we were saying, it's 8 minutes past 5. Maybe we can stop until 15 past, and we have 7 minutes to maybe grab a coffee. And I don't know if they have solved the problems with the connection with Professor Nylund. So let's take a little break, but don't go away. Not too far.